Hutchinson notifies Wyandotte, but then they go ahead and release him. Judge, I have another thought as an alternate means of what he's trying to accomplish here. I mean, I realize the allegations in the motion for probation revocation, those are correct, that he didn't report as he was supposed to, didn't do his substance abuse, didn't make restitution payments because he got in trouble in Johnson County. So I guess as an alternative, Judge, I'm asking if you decide go ahead and revoke him, but maybe then with the realization that the reason he didn't report, et cetera, was because he was in Johnson County jail and then prison, maybe reinstate him. And then once he's released from Hutchinson, that would get rid of any detainer. And then when he's released from Hutchinson, of course, if he doesn't report on his Wyandotte County probation, then a new motion would be filed, I'm sure, to revoke. So that's what I got, Judge.
Okay, well, here's what, if we do this hearing, then we're gonna have, you know, I'll accept the stipulation and then both parties can argue what they want. I'm assuming the state's gonna want sentence imposed since he picked up new charges in a couple of different counties afterwards, at least according to the allegations. If he wants to withdraw his request for a detainer, then I'm not gonna be releasing the detainer when he's done with his prison time. He can come back here to Wyandotte County and answer, and he could either be reinstated at that time or revoked, whatever it may be, or we go forward today and I make the decision after argument whether what kind of sanction, if any, he gets.
I hear exactly what you're saying, Judge. I wonder if Candace can give a little input as to what her point of view on the motion for revocation, if it's heard today, would be. Candace?
Well, it would be along the lines of what Judge has stated already. He picked up a new case and he's doing time now for that case. And honestly, if he probably would have just been doing the stuff he was supposed to be doing for us, maybe he wouldn't have been in trouble. But it does put us in a bad predicament because now he's doing time for a different case and he has other things going on. And so if we leave it out here lingering, I don't know if Judge, if you could even take the detainer back or just put it on hold or just give him a warrant. Like, I'm not really sure how that could even play out for him. Because I don't know if necessarily if he even would want to try to do what he was supposed to be doing on probation if given that opportunity after he finishes his time that he's doing for his other cases.
Right. So again, I think a defendant would be hard pressed. You know, I don't know of any precedent for it, but he'd be hard pressed if he came in and said, you know what, after all, I've changed my mind. I want to withdraw my motion for disposition of detainer and do it later, to come back later and say, well, you didn't bring me back like you were supposed to. I want my case dismissed. He's not going to get very far in that. So I guess the question just comes down to, we will eventually have a full-blown revocation hearing in which I'll hear everybody's arguments, and it can either be today or when he's done with his sentence and they bring him back to us. It doesn't really matter to me one way or another. And I'm not trying to give any kind of clue as this is what I'm going to do, this is what I'm going to do. I'm going to listen to everybody's arguments, hear any mitigation that Mr. Olson might have, and then make a decision. So we can do that today, or we can do that, you know, as he's getting released from Hutch. It doesn't matter to me. I think that's just up to Mr. Olson.
I think probably, and I guess he's listening, his preference would be to not have it heard today because that might get him revoked today and he'll get a sentence then, which I think maybe would be consecutive with Johnson. And so I think the number one thing, and I don't know about the notification detainer, Judge. I don't know. I honestly don't know about that. It's kind of a new one on me. But I think, and he'll speak in a moment, I'm sure, is that he does not want to probably go ahead and face the possibility of getting revoked and sentenced to the DOC on Wyandotte time instead of maybe waiting until he's released and then have a full hearing and maybe get him a reinstatement or something then.
I've never heard of a notification detainer, and here is I'm not releasing this warrant until we have this hearing. So if he finishes up his sentence in Hutch, my warrant's going to be active, and they're going to bring him back here, and then we'll have the hearing on that date. There's not a way to file a detainer that says, I know you have a warrant for me for a detainer, but they're just going to let you know when I'm released and let me go. That, to the best of my knowledge, will not and cannot happen. The only way that that would happen is if I were to say, oh, it's fine, go ahead and release, you know, we won't issue a bench warrant, we'll just trust him to come see us. And I'm not in a position to do that. So if he doesn't want to do it today, then the warrant's just going to sit there. And when he's done with his time, instead of just being immediately released, he'll be sent back to Wyandotte County, and we can take it up at that time.
I understand all that, Judge. So now it comes back to Tyler needs to tell the court what he wants to do. Does he want to go ahead and have the revocation hearing right now, or sit there until Hutch is done with him? So that's where we're at, and I get what you're saying, Judge.
Yep. Mr. Olson, first of all, any questions for me?
My question is, Your Honor, is my probation in Wyandotte County, I did report there to see Mr. Levin. They were supposed to be doing transport paperwork to Douglas County for me to be overseen in Douglas County. Once I was sentenced on my Douglas County case, I still have not been sentenced down there, and nobody ever got a hold of me of who to get a hold of down there. I did get my drug and alcohol evaluation done.
All right, this is not, if you want to do the hearing today, that's fine, and you can tell me all these things, and the state and Mr. Levin may take their positions on it. So it's not that I'm not interested in what you have to say right now, but what my question is to you right now is, do you want to do this hearing today? I can listen to what everybody has to say and decide what should be done. Or do you want to wait until you're done with your time in Hutch?
You know, Your Honor, I'm not 100% sure what I want to do on the revocation hearing yet, because I'm not, you know, if I do get revocated, you know, I've been down now since March of 19. You know, it's been a little over a year. I've had a lot of time to sit back and think about stuff, but I've got, my thing is, the reason why I'm trying to get this taken care of is so that I could be home by Christmas this year, because I do have my fiance with a lot of medical issues. That's why I'm really trying to get things taken care of, and I'm minimum custody, but I'm being held at medium facility. So, I mean, it's kind of deterring me a little bit having this detainer.
Okay, I get that. So, like I said, if we do it today, there's one of two things are going to happen. And Mr. Dent came in and said you didn't really have a challenge to what they said happened, but explanations why things weren't done. If we do it today, I'm going to listen to what you have to say, what your attorney has to say, what the DA has to say, and then I'm going to decide whether or not to revoke your probation. So one of two things comes out. I either revoke your probation and this sentence gets ordered to run consecutively to all of your other cases, or I don't and I put you back on probation. I can't tell you right now, before we have the hearing, which of those I'm going to do. Your other option that I'm giving you today is, it seemed like from your motion to modify detainer, you were basically withdrawing your request to be heard within 180 days and not wanting to have this. I can do that as well. But at the end of that time, let's say it says your earliest out is October of 2020. Let's say you're released in October of 2020. Instead of just releasing you, they're going to send you back here to Wyandotte County. and we can have our hearing at that time. And again, I don't know what I will do with that, whether I'll revoke you, reinstate you, whatever it may be. So the first question that I have that you need to answer is, you want to do this today, or do you want to do this when you get released from Hutch?
I mean, oh, man, I'm not sure, Your Honor.
All right. Here's what I'm going to do. We're going to all jump off of here right now, and I'm going to note that you're unsure what you want to do, but your last motion was to withdraw your request to be heard within 180 days. If you want to be heard, you need to file something again. You clearly know how to do it, saying, I want my hearing, and you'll get your hearing. If you don't, then just sit on it. And when you're done with your time in Hutch, they'll bring you back to us. Sound like a plan? All right. And do you need and look, Mr. Dent, are you still appointed? Is that why you're here? I know it was a pro se motion.
Yeah, I was appointed and I'm still appointed, I presume. That's why I'm here. Yes.
All right. So you can reach out to Mr. Dent, and if you want his advice, he can give you advice. But I mean, at the end of the day, it's going to be your decision what you want to do. Okay? All right. Well, I'm going to note that the defendant at this time has withdrawn his request to be heard. I know we're not on the record. Has withdrawn his request to being heard within 180 days. But he may reinstate that. And I'll do it. Heck, we won't wait 180 days. If he decides he wants a hearing as fast as we can get it turned around and scheduled up, we'll do it. You just need to let us know. All right, Mr. Olson?
All right.
All right.
Hey, so does that mean that, say I do, say in a month from now, I decide I want my hearing, you guys will put in for transfer up there, or just do it this way?
We can do it this way. I mean, it seems like the healthiest for everybody. But then again, if you demanded to be seen in person, I'd bring you back. It might take a little longer to get to your hearing, but I'd do it.
I mean, that's just one of my concerns, is this whole coronavirus stuff going on. You know, I'm not trying to be put at any risk, because I'm pretty safe where I'm at, you know.
I 100% get that. And that's kind of why we do it like this when everybody agrees to it, okay? All right, Mr. Olson, we'll keep in touch with Mr. Dent. File something if you want to be heard, and we'll get it set right away, okay?
All right, thank you.
All right, thank you, everybody. Have a good day.
All right, thanks, Judge.
You bet.